Welcome to the legal podcast containing legal questions and answers in layman's language. Today's topic is workers' compensation. Hi, I'm John Dearie, and I'm delighted to welcome as our expert guest Michael Dearie, who is an attorney that's represented the city of New York in thousands of workers' compensation cases and is currently represents clients who are injured in workers' compensation in the law firm of Finkelstein, Meyerowitz, and Edlitz. And Michael, welcome.
Thank you. Glad to be here.
So let's begin, Mike, by to be eligible for a workers' compensation case, what criteria would a client be responsible for?
Yeah, so a workers' compensation claim is a claim made by an employee against an employer when an injury arises out of and in the course of employment, and when the employee notifies the employer of the injury within 30 days and produces medical evidence linking the injury to the work accident. Any individual in the state of New York who has an employer-employee relationship and is injured and meets these criteria can file a workers' compensation claim.
It's very interesting you say that because my first question was, who can make a workers' compensation claim? You've answered it, and so it means throughout the country you've got employers and then you have workers, and you're saying that across the board, any worker injured in the course of their employment can file a workers' compensation claim.
You said across the country. The workers' compensation statute is a state statute. So each state has their own interpretations of the workers' compensation statute. New York was the first state to implement a workers' compensation law, and the New York State general body of law through the statute has been adopted by a number of different states, but each state has their own unique criteria.
So client X is injured on January 1st of a year. When must that file of a workers' compensation claim be made?
Well, we should create some distinctions there because what you want to understand first is there are types of claims. You have your most common type of claim, which we would describe as a discrete accident. A discrete accident is an accident that most people could understand. Guys works as a carpenter. He's climbing up a ladder. He falls off the ladder and breaks his arm. That's a typical discrete accident type of claim. And the claim could be someone falling off a ladder. It could be somebody carrying a box at work and tripping and falling, lifting something at work and hurting their back. So anything that is a discrete accident where an injury occurs in a specific moment, that is a type of claim. But then we also have a type of claim called an occupational disease claim. Occupational disease claim is a little different in that it's not happening at a specific moment. Occupational disease claim, best example would be somebody who is a stenographer, a court reporter, who all day their job, they're typing. As a result of their typing, that particular type of job, a court reporter, develops carpal tunnel in their wrist more commonly than the general public. That person working that job can file a claim if they develop carpal tunnel and they believe it's connected to their work activity as a court reporter. They will be able to file a claim for an occupational disease claim. So there's two types of claims you can file. And understanding what type of claim you have would then set the statute of limitation as to when you can file the claim. For a discrete accident, you have 2 years to file the claim from the date of the accident. For an occupational disease claim, it's a little different because the claim develops over time in the course of somebody's work. The analysis of when the claim must be filed is when the claimant knew or should have known that the injury was due to their work activity.
And how long is that period? What is the period?
Once that determination has been made, which is called a date of disablement, which there's a number of different factors that go into determining the date of disablement, and the Workers' Compensation Board has significant discretion in setting that date. Once that date is set, then the claimant would have had to file the claim within 2 years of that date.
I'm a little bit unclear that a file to the Workers' Comp Board must be made within 30 days, but you have 2 years, for example, as you described, to file a case. I'm a little unclear on those two numbers.
Yeah, let me clarify that. 30 days is the amount of time a claimant would have to notify their employer of the accident and injury. Now, the statute says that the notice must be in writing, but you can provide notice. A number of different ways have been accepted by the courts as providing notice to the employer. But one of the prime criteria of notice would be the employer must have notice within 30 days of the accident.
That you've clarified that. That's good. Question is, what constitutes the information needed to be able to file that claim with the employer?
It's very simple in filing a claim. It's essentially a 2-page form that the Workers' Compensation Board has called the C3 form that you would provide the general information about your claim when you provided notice to your employer, and you would submit that to the Workers' Compensation Board to start the process. Now, the Workers' Compensation Board will eventually need submission of medical evidence of the injury to continue the case forward, but the prime filing form in the state of New York is the C3 form.
And in terms of, just because I think it's of some importance for potential clients that may be listening, and that is that what is some of the details that are required in the notice of claim?
So
I don't mean the notice of claim, in the claim for workers' comp.
Yeah, the C3 form is just very basic general information that you're going to be providing, your name and general information about yourself, about your employer, about the accident, about the sites that you had injured in the accident, about who you provided notice to, about whether you have sought medical attention, and whether you have any prior injuries to these sites.
Where would an injured client get a copy of the claim to be able to file?
All of the forms can be found on the Workers' Compensation Board for the state of New York. The board provides ample amount of detail for claimants and provides access to all the forms, so that's all available.
Do I understand correctly that the form needs to be signed?
Yes, the claimant filing the claim must sign the form.
I want to touch on the issue of the statute of limitations, and I think that you began to touch on it a little bit. But why don't you talk about the statute of limitations impact on workers' comp?
You know, the statute of limitations is an issue that obviously, if you don't file within the time period of 2 years, your case will likely be disallowed. But you know, beside that, it's a fairly simple part of the statute. It's just setting forth that if you have a discrete accident, you must notify the board by initially filing the claim through the C3 within 2 years of the accident. That's it. If you meet that criteria and you file your claim within that time period, you've met the statute of limitations. Where that becomes somewhat of a more complicated issue is when we get into the occupational disease, as I had mentioned, because there's more of a question as to when the date of disablement should be set, based on when the claimant should have known that the injury was work-related.
Who is the claim made to? I understand it's to the Workers' Compensation Board. Is that correct?
The Workers' Compensation Board is the body that oversees the workers' compensation system. The system is created through the statute, and the board consists of the judges who essentially are the referees between the parties. What often happens, let's take, for example, a situation where an individual is hurt at work and they can't go back to work. When they can't go back to work, the insurance carrier oftentimes picks up their wages. Now, the insurance carrier has the opportunity to have the claimant examined by their own doctors. This would be an independent medical examiner. And oftentimes, the independent medical examiner of the insurance carrier has a different opinion as to the degree of disability of a claimant. And at that point, the parties will often have to depose doctors and make arguments before the board. And the board acts as the referee. The board has the judges with the experience to interpret the medical records and make determinations on legal matters and determination on medical matters as to the credibility of the doctors after testimony. And so the board's job primarily is overseeing the function of the workers' compensation system, making directions to the parties and working as the referee in situations where the parties can't agree.
Do injured parties believe they have a workers' comp case, but in fact do not as a result of evaluation? How often does something like that happen, or is that a very rare situation?
So what I think you're asking there is the question of whether claims are challenged, whether they're denied. When an injured worker files a claim by filing the C3 and filing their requisite medical evidence, the Workers' Compensation Board will index the claim and they will notify the carrier and the employer that a claim has been filed. At that stage, the carrier has an opportunity to review, speak to the employer, and determine whether or not the claim is legitimate. Now, a vast majority of claims that are filed are accepted claims, meaning that the insurance carrier has spoken to the employer has acknowledged that this individual fell down the stairs at work and they notified them and they were taken by ambulance to the hospital and they haven't returned to work. In this situation, the employer is not going to challenge the fact that their employee was injured. In that situation, the carrier will accept liability for the claim. That's a majority of claims are accepted in terms of liability. Now, some claims are not accepted in terms of liability. And I think that will bring us into the topic of what type of claims would not be accepted or what type of claims would be rejected and what would be the reasons for rejecting a claim. Or as we would say, controverting a claim. Why would the carrier controvert a claim?
I was going to begin the other way around and ask not what are some of the types of cases that are not essentially valid, but I want to ask, how would you classify the general types of injuries that you've experienced in the workers' comp field?
I mean, every type of injury imaginable. I mean, injuries as small as a laceration on a pinky finger, and as major as people being killed on the job. So, it runs the gamut. But, there isn't a threshold for an injury at work. You can have a sprain. If you feel a pop or a pain in your ankle as you're lifting a box of papers to put into the printer, that pop alone, if you go see a doctor, that could be a sprain that could result in a workers' compensation claim. So the type of injury, the types are endless. Just to touch on that, on top of orthopedic injuries, which would cover, sprains, strains, breaks, anything like that, there's also psychological injuries, and that's an entire other end of workers' compensation claims that individuals can file. If they've experienced some trauma at work that's above and beyond what the average worker in their position would experience, they can file a claim for a mental stress injury.
To flip it the other way, do you have an example or two of a case that is presented but rejected, essentially, does not meet the criteria of a workers' comp case?
Yeah, certainly. Some easy factors would be not notifying your employer within 30 days, not filing within the 2 years as we discussed. But then other factors could be credibility of the claimant. Sometimes claimants file and they say that they injured their back at work, and their employer has witnesses that say they never saw the individual get hurt as they said they did. And the board assesses the credibility of the claimant after testimony of the claimant and determines that they don't believe the claimant and that they don't believe the accident took place as the claimant said. That could be a grounds for dismissal. There's also medical reasons. People have prior injuries. Maybe somebody had a prior back injury and they're at work and they lift something and they have pain in their back. Now, that opens up the door to the question of, was this something pre-existing and just an ongoing issue that this individual had, and whether or not they picked up the box at work, they were going to have this condition, or did the box at work exacerbate their condition or make it worse? Those questions could, make or break a claim.
Can a dismissal of a case be challenged in the court?
Yes. The appeal process is that the Workers' Compensation Board is the trier of fact. And so the testimony of claimants and doctors and witnesses takes place before the board and before the judge. And just like a trial court level in criminal court or personal injury, the board is the trial level of the court. Now, the claimant, if the judge makes a decision that the claimant disagrees with, or vice versa, the carrier disagrees with, the parties have the opportunity to appeal. They can appeal to the higher level of the board. And if they're denied at that level, then they can appeal up to the third department. In New York State, the third department covers workers' compensation. So any appeals above will be to the third department, and in the rare situations from there up to the Court of Appeals.
Do you think that the Workers' Compensation Board gives a fair evaluation of cases and designations, yay or nay?
I think the board does the absolute best job they can. It's a difficult job and oftentimes requires tough decisions, but I think the judges and the board does the best it can, and I think they do a noble job.
One of the most important topics to speak of in workers' compensation are cash benefits. So maybe you'll discuss that.
Very, very important, yes. I should have said this at the beginning, but in filing a workers' compensation claim, what you're seeking benefit of are two things: medical coverage for causally related medical treatment due to the injury. So if you injured your shoulder, you're entitled to, you injured your right shoulder, you're entitled to treatment to your right shoulder. If you have a claim to the right shoulder, you're not entitled to treatment to your left foot. So you're entitled to the medical. Now, on the indemnity portion, workers' compensation covers wage loss. Okay, and so wage loss is interpreted and can be compensated. Really, there's kind of two ways. First is the individual who is injured at work and can't return to work due to the injury. When somebody is out of work due to the injury, they must go see their doctor and produce medical evidence commenting on their degree of disability every 90 days to be entitled to workers' compensation benefits. Now, the percentage that the doctors determine and ultimately the board determines that a claimant is disabled is the percentage of their rate that they are paid at while they're out of work. So if somebody is out of work and the doctors agree they're 100% disabled, they will be paid 100% of their average weekly wage. If the doctors agree that they're 50% disabled, then they'll be paid at 50% of their average weekly wage. So that is the determination, and that is how compensation is paid to claimants while they're out of work. Now, individuals can get injured at work and not miss time. There's plenty of individuals who work and may have fallen and injured their shoulder, for example, but continue to work despite the injury. And then how does that person get compensated? Well, if you're able to continue working, you can't make a claim for lost time. But at the end of your claim, for example, if you have a shoulder injury, you can be assessed for a schedule loss of use. And a schedule loss of use is a determination, a medical determination and a legal determination, as to what percentage of loss of use a limb has sustained as a result of an injury. And that corresponds to a calculation that will represent an amount of time that the Workers' Compensation Board estimates that the injury will result in this person not being able to work. And that estimated amount of time will be paid to the individual in a lump sum. So there's really those two ways to be paid. You can be paid if you're out of work on a weekly basis, or if you remain in work, you can be assessed for a permanent impairment at the end of your claim.
How is that calculated, the permanent one? How is that calculated for someone that is continuing to work?
It's a rather complex analysis, but to try to separate it a little bit, there's a difference between injuries to your extremities, meaning your fingers, your hands, your shoulders, your elbows, your wrists, your knees, your hips, your ankles, your feet, your toes. Each of those sites has a value to it in number of weeks. Okay. And so when the doctors assess, based on a series of guidelines and medical criteria, what a percentage loss of use is for each of those sites, those percentages equate to weeks of benefits. And so the assessment by the doctor in terms of schedule loss of use for injuries to the limbs is one way. Okay. Now, injuries to what are not schedulable sites, meaning your neck, your back, your brain, the post-traumatic stress disorder, these type of injuries resolve on something called a classification, where an individual is found with a permanent partial disability or a permanent total disability, and based on that, they'll be entitled to a number of weeks of benefits paid out on a weekly benefit.
Is there a maximum weekly benefit under compensation?
Yes, there is. Each year, the board issues new guidelines as to what the maximum payout per week will be. And so, depending on the year in which you were injured, the maximum amount of payout per week is determined by the Workers' Compensation Board by the year of your accident.
And do I understand that there's a minimum weekly benefit too?
There is a minimum weekly benefit. It was for a number of years $150. It has gone up starting as of 2026, January 1st, 2026. The minimum balance will be $300.
Now, let me understand that on the minimum. Someone files a claim that you're saying that the minimum amount that claim, if it's in fact accepted as a claim, the minimum that person would get would be $300 a week. Is that what you're saying?
Yes.
So that would have
Well,
to be.
yes, with some exceptions. What you're touching on there is something called the average weekly wage, which is important to understand. The average weekly wage is set, and that is how all the rates are paid out and how all the determinations are paid out. And how an individual's average weekly wage is set is if the person was working substantially the whole part of the 52 weeks prior to their injury, the average of that will set their average weekly wage. It's done on a calculation, a 260-day multiple calculation. But what you touched on raised an issue of, well, what happens about individuals who don't work the whole part of the year? How about people who work part-time? Their wage gets set a little differently, and their rates get set a little differently because the board determines that the wage has to be something of an accurate reflection of what the individual would have made in a year. So there can't be an averaging of somebody who has a part-time position throughout the whole year.
I think one of the most important aspects, as I understand it, of workers' compensation is that no proof of negligence, I guess, is required to have someone who is injured in a job activity, so that there is no proof required. If someone's injured, they're eligible for workers' comp. Is it as simple as that?
Well, proof is required of your medical documentation providing causal relationship to the injury. But when you say, is negligence required? No. Negligence is a topic people are often familiar with in personal injury. The workers' compensation statute created in New York was created as a way, sort of as a compromise between employer and employee. What they didn't want happening was endless lawsuits between employees against employers. They wanted to come up with a better system to more quickly compensate injured workers and, avoid the legal tie-ups that filing claims for negligence would have caused between the employer and the employee. And so they structured the workers' compensation statute to provide a system where an injured worker doesn't have to prove negligence against the employer and is entitled to workers' compensation benefits per the statute, per the guidelines, within the minimum and maximum payout rates. And the advantage to the employer is the claimant does not have an opportunity, or the employee does not have an opportunity to sue their employer. So that's the trade-off. And the benefit to the employee, as you mentioned, is that, no, they don't have to show that their injury was caused by some negligence on the part of their employer. They simply have to show that they sustained an injury while in the course of their employment, and that the injury arose out of their employment, meaning that the injury was connected to their work. If individuals who are, a classic example would be somebody who's at work, but then they leave for lunch and they go have lunch and they're walking back from lunch and they trip and fall and are injured. That did not arise out of and in the course of their employment, even though they may have gone to an office, left the office for a little bit, and then were coming back. It broke the connection with the work. So that would be an example of, a case that would be disallowed for not meeting the criteria of a workers' compensation claim. But that's sort of a demonstration of, if you were injured at work, maybe just lifting a box, nothing, the box wasn't left improperly, it was, it wasn't You didn't slip or anything as a result of your employer's negligence. You just lifted the box that your employer instructed you to lift, and you injure your back. That's a workers' compensation claim. You don't have to show negligence on the part of the employer.
I'm curious as to what, based on your experience, is the perspective of employers as it relates to workers' compensation or workers' compensation claims.
Well, the perspective of the employer, that's the law of the land. So I think the perspective of the employer is it's a functioning system, and most employers are looking to make sure their employees are taken care of when they've been injured. I think the cases that are controverted by employers are generally, for the most part, cases that employers feel have been filed for inappropriate or improper reasons. Now, do you have employers who take unnecessarily aggressive stances and controvert claims that should be accepted? Yes, but for the most part, I think employers are receptive to the idea that this system has been created to assist their employees who have been injured at work.
What advice would you give to an individual who had a job and was injured on the job? What should their perspective be with regard to the workers' compensation program?
Well, you want to obviously get to a doctor as soon as you can, and let them know that you've been injured and provide the history and the mechanism of the injury. You want to have medical evidence of your injury as contemporaneous to the date of accident as possible. Now, that doesn't mean you must have it within, a certain amount of time. You don't have to. You can file your claim with medical evidence, well beyond a year after the date of accident. Now, then you're opening yourself up to additional questions from the employer or the carrier as to the legitimacy of this accident, which is why I would always recommend individuals who have been injured get to the doctor as soon as possible, and make sure they put in their report that you were injured at work, and tell them how you were injured at work.
What's your experience in terms of people coming to you as an attorney looking for workers' compensation representation, where you might be talking with them and you don't feel that there is a case?
Yeah, that happens occasionally. Somebody calls and they fall within those criteria that we've discussed. Somebody calls and says, I was getting in my car driving to work today and I was in an accident. Do I have a workers' compensation claim? Unfortunately, no. We would want to really flesh out the details. There's times when somebody gets in a car and is driving from their home to work, and the car they're driving in is their employer's car that they were told to drive to work. So there's times when we want to get all the details, but sometimes I'll get a call from somebody, I'm driving to work and I was in a motor vehicle accident. Do I have a claim? No, because the motor vehicle accident on the way to work did not, as interpreted by the law, arise out of and in the course of your employment. You had not begun your employment yet, so you don't have a claim. Those calls come in, and we certainly try to be as frank and honest with individuals as possible. But if there's some ability to look into the details of the claim, maybe there is potentially a case there after all. So that's why you want to speak to an attorney and provide as much details as possible, because you never know. Some claims might not seem like a claim at first, but you dig in a little more and you might find that there is some details that make the claim arise out of one.
If an individual dies as a result of a workers' comp related case, can the spouse or children bring an action on behalf of the deceased?
Yes. There are death benefits for survivors of a deceased individual. Those benefits, and there's calculations as to how the breakdown goes, but for dependent wife or dependent husband, and then dependent children would be entitled to benefits at the max rate, the total weekly rate. So yes, survivor benefits are available to those dependent on a individual who died in line work.
Mike, workers' comp is a very important element of our legal system. Clearly, you know A to Z about it, and thank you very much for providing us the information tonight.
Thanks so much. Glad to be here.
Each month, there will be 2 podcasts available for viewing. The first one will begin on the 1st of the month and run to the 14th, and the second one will be from the 15th until the end of the month. And so I have no doubt that you enjoyed today's presentation on workers' compensation, and I hope you look forward to enjoying others in our program. This again is John Dearie, and thank you very much. Have a nice evening.